understanding of labor law, right? So I'm asking you a simple question. What is the starting point of labor law? Okay, that we may state with the help of one particular example, right? Suppose you hire some taxi to go to airport, right? The taxi meets with an accident. Whether the taxi driver can claim any compensation from you under Employees Compensation Act, number one. Number two, you hire some driver to drive a vehicle. The driver is subject to your supervision and control, right? And thereafter, the driver meets with an accident. Whether that driver can claim some compensation under Employees Compensation Act. Number three, J.S. Mann is a teacher, right? J.S. Mann is a teacher. Whether J.S. Mann can approach a labor tribunal, labor court for ventilating his grievances, because J.S. Mann has been removed from service without following principles of natural justice. I hope you understand paradigms of principles of natural justice, right? Okay, now let us see all three paradigms. So we are going to discuss some important parameters of labor law, right? I'm told you are studying labor law and you have some good understanding of administrative law, right? Otherwise, I had prepared my presentation on research methodology, how to conduct good quality research, right? Number two, how to frame or draft some research proposal, right? Number three, efficacy of AI tools and techniques in conducting research, right? I was under the impression that I'm going to discuss three parameters, but since you have that specific subject, so let us have some extempore discussion and interaction regarding labor law. Fine. So let us see. See, number one, you hire a taxi go to airport, right? On the way, the driver meets with an accident. Number two, you hire somebody to drive your vehicle, right? And the person is subject to supervision and control. The person meets with an accident. What you are liability under labor law? Third, J.S. Mann is a teacher, right? He has been removed from service without following any principles of natural justice. No prior notice has been given. Do you think J.S. Mann can approach a labor tribunal or labor court for that purpose? Let me see some arguments. This is directly related to contract of service. This is directly related to labor law. So if I ask you, what is the starting point of labor law? Anybody? Have you studied labor law? Which part of labor law has been examined by you? Trade Union Act. Okay, number one. Number two?
Standing Orders Act.
Employment Standing Orders Act 1946. Industrial Disputes Act 1947. And I hope you are well versed with that latest development, the labor law reforms, second generation of labor law reforms introduced by the government, 4 courts, right? So if you examine all these statutes, Trade Disputes Act, now we have Industrial Disputes Act, right? Trade Unions Act, Employment Standing Orders Act, right? And IR Code for that purpose. Can you examine all these statutes without understanding fundamentals of labor law? See, it is very easy to examine any statute, right? This section 1, section 2, section 3, section 5, etc., etc. So number one, understanding a scheme, the provision, the statute is easy. But again, integration the scheme is very important. Section 1 may be related to section 40, section 29 may be related to section 7A, right? Or section 11A of ID Act or Indian Act. So this approach is very important when you talk about any subject, let it be a labor law, administrative law or contract law or maybe any law, right? So friends, can you examine Industrial Disputes Act without understanding the contours of industrial relations law? So friends, yeah, let me see some arguments. It means you have not understood anything about labor law till date. Of course, you have studied Trade Unions Act 26, right? Association, registration, etc., etc. 17, 18, 19, 3 important provisions of trade, that Trade Unions Act, immunity, protection, privileges, etc., etc. So it means you have not understood what is labor law. What is the real character of labor law? Okay.
in an organized sector.
See friends, when you talk about any subject matter, there are three W's, you know, three W's? Three W's of subject matter analysis. Whether you talk about strike, talk about lockout, retrenchment, layoff or any concept. Kindly always look for three important parameters for subject analysis. You know something about three W's? Yeah? Okay. Anybody else? Let me see some arguments. Yeah. See friends, I don't believe in monologue. I strongly believe in dialogue. Right? Whenever I go to classroom, I enjoy interaction discussion with students. And I expect students to know basics. Right? I know the students to really prepare for the discussion. In case you come to classroom without basic understanding of subject matter, then what the purpose of really that kind of interaction discussion? Right? According to your statement, I am given to understand that you have studied Trade Unions Act, you have studied the Employment Standing Orders Act, you have studied Industrial Disputes Act 1947. I am asking simple question, right? And that is the basis of labor law. Yeah, you know this section, this provision, that provision, fine. But you are not in a position to really appreciate that. Let me see somebody. Anybody? Starting point of labor law. And before that, three important, yeah?
Exploitation.
Okay, exploitation is a starting point. But labor law facilitates. It is not only, see, exploitation is one important component. Labor law facilitates. It protects. Right?
If we examine it, sir,
yeah.
then we will see its root in the French Revolution 1789.
Okay.
It is part of social justice system and socialism. So, what I understand in modern history, that labor law begins with the successful revolution in 1789 of French Revolution.
Okay.
Yes, sir.
Before that, there was no history of labor law.
Industrial labor law.
That is why I chose the word modern history.
Right.
Modern history.
Fine. Okay, fine, friends. See, I tell you, this is not the way you are going to excel in the field. Right? So you must empower yourself. And how the person can be empowered, you must know your subject matter. So, okay, fine. See, number one, whenever you examine any concept, any theory, any doctrine, any law, can you look for three important parameters of the subject? Number one, labor jurisprudence. The starting point is, what was the law? Just try to trace out that jurisprudence, labor jurisprudence during ancient time. You may relate it to that Arthashastra. Arthashastra is a wonderful piece of literature. Right? Just examine that literature from the perspective of fixation of wage, working hour, disablement, other liabilities. Then thereafter, historical development regarding Egyptian that civilization, right? Civilization in other countries, slave, etc., etc. Right? So number one, labor jurisprudence. Jurisprudence may be related to strike, status of strike. Then number two, what is the law? Second W is, what is the law? Because you are part of LLB. So you are expected to know the legal status, basic characteristics of law, the concept. Number two is, what is the law? Number three, what ought to be the law? So therefore, it becomes very important that you must understand what are the limitations of existing law. How far existing law is in a position to protect workers. Now there is too much of contractualization in 21st century, you know, right? Everything is outsourced. Everything is subject to some kind of third party involvement. We call it a contractor, subcontractor or any other person, right? So this is with respect to interpreting, analyzing, understanding a subject matter. Number one, understanding. Number two, applying. Number three, interpreting. Number four, analyzing, making recommendations. This is the way how you learn from the literature. Now coming back to the important issue. What is the important issue? What is the starting point of labor law? What is the originating point of labor law? And when it comes to historical perspective, you must understand what was status. Right? Workers were traded in open market like slave. I'm talking about ancient time. If you talk about civilization, workers were traded in open market like commodities. Right? Without any rights, without any entitlement. Right? So that time, what was the relationship? Owner and slave. Thereafter, master and servant. Thereafter, employee and employer. And now you know, right? You have some kind of association where workers are treated at par. They are considered partners. You know, in law firms, what is happening? Right? Workers are designated as partners. So don't go by the designated person. What is important? Understanding the application, the point of labor law. Let me see. Have you studied the judgment? Short versus J&W Henderson, 1946, House of Lords, Lord Tankerton. That is, I think, the Bible of labor law. Number two, have you examined this Dharantara Chemical Works versus State of Saurashtra, 1956-57? Certainly not, isn't it?
No, yes.
So if that is the case, how are you going to really examine labor law without understanding basic parameters? The taxi driver would be covered under contract for service. Right? You hire some driver to drive a vehicle and the person is subject to supervision and control. You pay him. You have right to dispose of the services. Then the person is engaged under contract of service. That is contract of employment. Right? Now when it comes to whether J.S. Mann can approach a labor tribunal, that is again a problem. Because J.S. Mann has not been considered a workman by Supreme Court in several judgments. Right? That 1953 judgment of Delhi University Ramnath. Then thereafter that judgment of Bangalore Water Supply. Thereafter that Sundarambal 1990 and so on. So a teacher is not a workman. So therefore there is no question of approaching a labor tribunal. Fine. So when it comes to contract of employment, right, if somebody who is covered under contract of employment or contract of service shall be covered under labor law. So if that is the case, what are parameters of contract of employment? Anybody? There are 4 parameters according to Lord Tankerton in Short versus Henderson judgment of 1946. Same has been repeated by Supreme Court in the judgment of 1950-1957. Dharantara Chemical Works versus State of Saurashtra. 4 parameters, anybody? And the same has been acknowledged by UK Supreme Court and a wonderful judgment, that Uber versus Aslam judgment of UK Supreme Court, February 2021. Anyone? 4 important parameters of contract of employment. Right? So how are you going to really identify whether the person is an employee or not? Whether the person is covered under labor law or not? How are you going to identify? 4 parameters. Let me see anybody. 4 parameters of contract of employment. Number one is power to appoint. That a person has been appointed by another person, right? We are talking about that employer has the power to appoint employee. Right? An employer cannot exist without employee. Employee cannot exist without employer, and employer cannot exist without employee. Right? If there is a person called employee, it means there is an employer. If there is a person called employer, it means the person has employed somebody. Right? The starting point is the person must have been employed by somebody. Number 2, obligation to pay for remuneration. Right? Number 2 is that employer has been under obligation to pay for remuneration. Right? So there is an obligation on employer to pay for services rendered. Number 3, that is most important component of this relationship. This relationship between employer and employee is based on the 3rd important component, that is that employee must have been subject to supervision and control by the employer. Right? And the supervision and control can be direct through direct control or through indirect control. Right? So the Supreme Court, UK Supreme Court in 2021, that Uber versus Aslam has recognized indirect control, that you can control and apply through artificial intelligence tool. Right? You develop some app, control drivers, so they will be covered under that control and supervision activity or the tool. Right? So number 4, that is also important. 4 is that employer has the power to dispose of services. Employer has the power to dispose of services. But the real problem in Indian context when it comes to labor law. Right? India has not accepted universalization of labor law. Right? India has not accepted universal application of labor law to all workers. Therefore, all workers who are covered under contract of employment are not covered under labor law. Labor law is subject to number 1, wage limit. There are several labor legislations which are subject to wage limit. Like in case of Provident Fund Act, you know there is a wage limit of 15,000 rupees. In case of Provident Fund Act, there is a number of workers and that employed requirement 20 workers. Right? In case of ESI, again 10 workers, then salary limit of 21,000 rupees. So India has not accepted universalization of a labor law. Most of the labor laws are related to number 1, salary. Number 2, number of workers. Can you just list out a particular labor legislation where this number of workers requirement or wage limit is not relevant? I am referring to universal application of labor law. Even a specific statute in India where that statute or the labor statute instrument has recognized universalization of labor law. Anyone? You know, universal application. All workers are covered, irrespective of salary, status, designation, etc., etc. Can you name any labor law? List out any particular labor law which is not subject to number of workers requirement, not subject to any salary requirement. Can you name any labor law? Anyone? Yes. Can you try? Employees Compensation Act 1923. You not studied that, right? Single employee is covered. If you have somebody to whitewash your building, etc., etc., and the person is subject to your supervision and control, the person suffer from some kind of injury while doing that assignment, then you will be held liable. Wage limit is not relevant in that case. Number 2, number of workers requirement is also not relevant in that case. Now, in case of minimum wages, it is something about labor law reforms. In case of minimum wages, last bench, can you just come forward? We don't like back benches. We like leaders actually. Come forward, please come forward. Yeah. So anything about Minimum Wages Act? Anyone? Have we accepted universalization of minimum wages in case of that wage code? Yes, we have accepted that. If you go by wage code 2019, yeah, we have accepted universalization. Otherwise, and the problem is all these labor codes have not been enforced till date. So as on date, all labor laws like minimum wages, IRA, Industrial Disputes Act, Trade Unions Act, right, are still valid. These statutes have not been superseded by labor codes. The moment labor codes are enforced, then you have different proposition, right? So everything will be regulated by labor codes. Labor codes, IR labor codes, right? Means that wages, and then your social security, OSH, working condition, etc., etc. Fine. So this is the way you must learn labor law. Fine. So when it comes to Trade Unions Act, have you studied Trade Unions Act? What is trade union? What is a trade union? And how far a trade union is different from association? Whether an employer can have association? See, this is Indian context. Other countries have not recognized employers association as trade union. We have borrowed it from Australia, we have borrowed it from other countries. But you compare it from other countries, they have not recognized association of association employers as trade union. They recognize association of workers as trade union, that's it. But see, Indian context. In case of industrial dispute between employer and employer is also covered under industrial dispute, whereas this is not covered under industrial dispute in other jurisdictions. If you see that Commonwealth Arbitration Conciliation Act, Australian Act, Statute of 1904, Section 4, from where we have borrowed the concept of industry. Have you studied in concept of industry? Industrial Dispute Act? Okay, not yet. Fine. So you have started with the Trade Unions Act, right? So Trade Unions Act 1926. Let me say some inputs regarding Trade Unions Act. Have you studied Complete Act of 1926, Trade Unions Act? Right? Fine. You know what the basic objective of Trade Unions Act 1926? Anybody? What is the basic objective of Trade Unions Act? Is it mandatory to have registration? Oh my God! क्या पढ़ा आप लोगों ने भाई? Is it mandatory to have registration of Trade Unions Act? Yes. This is so pathetic. It means you have not read anything. You don't know ABCD about Trade Unions Act. Registration is not mandatory. No basics. This is the starting point of Trade Unions Act 1926. Registration is optional, not mandatory. The moment trade union is registered, it acquires a legal status according to Section 13 of Trade Unions Act. It becomes a legal person, right? And legal person has certain rights. What are the rights which are available to a registered trade union? Let me see. What are the
Legal recognition.
to avail immunity protection, right? Acquire legal status. Fine, that is the basic objective. And that is the requirement for collective bargaining also. That is the requirement for selecting bargaining agent. A trade union, if you see Maharashtra's Act 1961, right? Or you talk about any state, MP also. A registered trade union is the requirement for designation as bargaining agent. Fine. Okay, now what about the civil immunity? Number 1, civil immunity. Number 2, criminal immunity. Number 3, Section 19 deals with any agreement in the state of trade and business shall not be void. Otherwise, by virtue of Section 27 of that Contract Act, all agreements restraining trade and business shall be null and void. But Section 19 is very specific provision dealing with that specific liability. Let me see what is the civil immunity available. Anyone? You have studied, you have examined the Trade Unions Act? Yeah. What is civil immunity available? Okay, fine. Let me just take it with the help of that. Suppose there is a trade union. Trade union is registered, right? It declares strike, and because of the cessation of work, employer suffer from loss of business. You know what is strike in any context, right? Strike may be legal, illegal, justified, unjustified. Fine. Now there is a person, there is an employer. Employer has suffered loss of production because of strike. Whether that employer can claim any compensation from workers? Why not? What is the protection available? Yeah. Under which provision that protection is available? Section? Okay. You know there is a landmark judgment by Justice B.R. Krishna here on this point, claiming damages from our trade unions for loss of production or for losses suffered by employer. Any specific judgment? Landmark judgment by Justice Krishna here. Which judgment? Anyone? 1975 judgment 1975. Which judgment? Anybody? What do you study? Which judgment? Have you? You know, Tas Industries 1975. Justice V.R. Krishna here. Right? Claims arising out of that damage or loss of business will not be part of the dispute for the purpose of Industrial Disputes Act 1947. So this is a civil liability where workers are protected, trade union leaders are protected. Employer cannot claim any damage for cessation of work, for a breach of contract. See, do you think strike is a breach of contract of service?
It's a right.
Yeah?
It's a right.
Oh my God. Do you think strike, right to strike is a legal right, constitutional right, moral right, ethical right, any right? Wait a minute. Yeah. Right to strike is a legal strike. Constitutional law, protected right, constitutional right, moral right, etc. What is status? Legal right.
Legal right, according to law.
Are you sure this is a legal right?
Yes, sir.
Okay, let me see. You know what? See, there is a, law is well established. There is a right, there is a remedy. There is a legal right, there is corresponding duty. Right? That is well established. Right? According to strike is a legal right. Fine? There must be some corresponding duty on the part of employer to recognize that right. Not to deduct any wage. No work, no pay principle. PS Kelewala, Bank of India, 1990. Number 2, K. Umesh Nayak was a syndicate bank, 5 judges bench, 1994. Just explain that according to right to strike is a legal right. Let me see. See friends, whenever you make some argument, now we are all legal professionals, right? Whenever we make some argument, we are expected to provide some reasonable support, right? Some relevant data, some relevant argument to support that argument. The right to strike is a legal right, isn't it?
Why do anyone do strikes for a reasonable cause? For getting their, if the employer is exploiting them, to make sure that he is not exploiting, they are getting their rights.
Let me see any other person. Article 19 1C, freedom of speech and expression. Article 19 1C is forming association. 1A, freedom of speech and expression. Right? So, do you think right to strike is a concomitant right to form association? B.R. Singh versus Union of India, several judgments. Yeah, anybody? Let me see. Anybody from this? The right wing, left wing, central wing. You studied strike, right? According to you, the trade unions are immune from any kind of damage, especially in case of strike. Let it be strike, legal strike or justified strike, right?
In all cases.
Trade unions are protected only in cases of the strike is illegal and justified. Fine, that is the law. If strike is illegal, not protected. Strike is unjustified, not protected. This has been held by Supreme Court in that RTS Kelewala versus Bank of India 1990 and K. Umesh Nayak also. But the K. Umesh Nayak judgment has developed this no pay, no work. See, no work, no pay theory also. Fine. So again, anybody else? Right to strike is a legal right or constitutional right or moral right or human right. According to legal right, what is justification? Is any provision recognizing that right? Any provision in any act, Trade Unions Act, maybe Industrial Disputes Act, or maybe that Employment Standing Orders Act, any act, let me see. Yeah. See, there is no negative marking, right? We are just learning because learning is a continuous process. We learn from each and every person, right? So therefore, no harm in accepting of our limitations. Let me see some arguments. You made that argument, yes, and you also supported that argument that right to strike is a legal right. Is it so?
Human rights.
Yeah?
Adding up.
Okay. See, human right covers everything. Moral right, social right, political right, all the rights are covered under human right. Because see, either the legal right, there is legal remedy. So easy to understand. Moral rights can't be enforced, social rights can't be enforced unless recognized by some particular statute. So we are talking about the protection because you have discussed section 17, 18, 19. Right? Yeah, let me see. Anybody? Yeah? Statute right means legal right. Isn't it? Statute right means legal right. Isn't it provision to recognize the right to strike as a statutory right? Section 20? Okay, section 22, 23, 24 of Industrial Disputes Act. Fine. 22 is applicable to public utility services. Right? 23 and 24 have different paradigms. Isn't it? Isn't any provision under 22 recognizing legal strike or right to strike as a statutory strike or legal right? Just open that, let me see. Read 22 of ID Act and just find out. Yeah. Section 22. You use mobile, no problem. Our students are very smart. Right. Let me see section 22. You just made that argument that section 22 of Industrial Disputes Act 1947 has recognized right to strike as a statutory right or legal right. 6 weeks, 14 days, conciliation officer, etc., etc. Right? This is section 22 of that act. 23 is other, right? 24 is otherwise. Is there any provision? So what is the significance of section 22? Section 22 provides for procedure for declaration of strike only in public utility services. Right? Yeah. Is it a recognition of that right to entitlement? See, whenever trade unions wants to declare strike, it has to give 6 weeks notice. No strike can take place within 14 days. There can't be any strike during pendency of conciliation proceedings, etc., etc. That's it.
Right to inform on the grounds of arrest, sir.
Huh?
Right to inform on the grounds of arrest.
We are discussing Industrial Disputes Act 1947, Section 22. ये अरेस्ट वरेस्ट कहाँ से आ गया भाई? हाँ?
I'm from Chat GPT, sir. I'm asking.
Chat GPT. I don't trust this. Right? Section is very specific. It does not deal with the arrest of a person. Right? Section 22 of Industrial Disputes Act. Similar provisions have been incorporated under Industrial Relations Code 2020. See, I tell you friends, this is, so be serious about that. Right? If you acknowledge your limitations, you can improve. If you don't acknowledge your limitations, you can never improve. So try to acknowledge your limitations, number one. Number two, never trust internet data. Internet data is highly unreliable. Right? So you need to verify that internet data from different sources. There are problems regarding internet data. Number one, authenticity. Number two, accuracy. Number three, latest data. Right? So try to verify the data from original source. We are referring to Section 22 of Industrial Disputes Act. It does not deal with arrest of the person. Right? It deals with procedure to declare strike only in case of public utility services. And public utility services has been defined by the Act, Section 2N of ID Act. I define that. Right? Just read 22. Yeah. Gentlemen. And the lady. What happened? See, you come to classroom to know, to learn, to grow. Otherwise, for the purpose of attending lectures, if you don't come prepared, right? You don't have basic understanding of subject matter. That is the real problem actually. Otherwise, you read books. What's the purpose of teacher? See, teacher is expected to go beyond books. Otherwise, read books, wear hats, everything is fine, right? So the role of the teacher is to really empower you, facilitate you. And teacher is not expected to believe in spoon feeding, the pampering approach. populist approach is, I think, is not required in case of any profession, including teaching profession. So my duty is to teach you how to fish, not to provide you fish. That is, I think, the basic requirement of this interaction between the stakeholders. Fine. So let me see 22. Let me see section 22 of ID Act recognizing our right to strike as a legal right. Okay. Read any of the provisions of section 22. 1, 2, 3, 4, 5, 6, etc., etc. Is there any provision where right to strike has been recognized as a legal right, statutory right? Yeah. 22. Don't refer to the arrest. Right?
Okay. Section 1.
Use your discretion, don't borrow it from others. You must be in position to decide what is right and what is wrong. Yeah. Cite any provision of 22. Let me see the lady there. Yeah, last. Yes. 22. Section 22. Do you think section 22 has a recognized right to strike, a legal right?
Indirectly, sir.
Yeah?
It is clearly given that no person employed in a public utility service
Ah.
shall go on strike in breach of contract given provisions.
Wait a minute.
If provisions are followed, he can refuse to go.
Wait a minute. Right to strike is always a breach of contract of service. Right? This breach of contract of service is protected only in one in particular case. Right? See, right to strike means no work, cessation of work. It means there is a discontinuation of contract of employment between employer and employee. Fine? But because of the procedure, in case the procedure is followed, that contract of service is protected. Section 22 deals with protection of that breach of service or discontinuation of service. See, whenever strike is declared, you see, Indian perspective of strike, cessation of work, concerted refusal, arising out of particular dispute. See, Indian context of strike is very different. Complete cessation of work. If you go to China, South, then Korea or Japan also, you know what happens in case of Japan? There was strike declared by bus conductors, right? They did not discontinue the duty, but they refused to circulate tickets. They refused to collect money. That was a kind of cessation of work in that country, right? So according to them, cessation of work doesn't amount to, the strike doesn't amount to cessation of work. That is very different nature. They accelerate the rate of production during strike period. But in Indian context, strike means no work at all. Fine. Coming back to the main issue. The right to strike as a legal right or statute right. Yeah, according to indirect. What is indirect? See, we are not competing friends. The basic objective of this interaction is to learn more and more. Right? It to create that awareness about labor law. Section 22, read all everything. Yeah. Any provision? Okay, fine, because we have very limited time. See, right to strike is not a legal right or statutory right or fundamental right. Right to strike is a recognized right. Recognized by section 22, 23, 24, section 17, 18 and 19 of Trade Unions Act. It's a recognized right. Right? The moment, see, the procedure is followed, there won't be any deduction in age. The procedure is followed, there can't be any discontinuation of course of employment because the period of strike, legal strike and justified strike would be taken into consideration for continuation of service. But if you go by section 9 subsection 2 of Payment of Wages Act, see again integrated understanding is important. When we talk about labor law, ID Act, then you must know strike, you must know other provisions regulating the strike. You have provisions under Payment of Wages Act section 9 subsection 2. That is deemed strike. Right? Just read that also after completion of this discussion. Right? So, that section 9 subsection 2 has recognized a deemed strike. Read that 10 or more person being absent from work. So right to strike is a recognized right. Fine. But what was the trend before 1990? Because the judgment of the TSKLA versus Bank of India 1990. Fine. Accept the doctrine, no work, no pay. Forget about the legal or justified or unjustified strike. The person has not worked, no remuneration shall be paid to the person. So there is no relevance of this justified or legal strike or anything. Same has been accepted by Supreme Court in that K. Umesh Nayak versus Syndicate Bank 1994 5 judges bench. No work, no pay. So if that is the case, if strike is legal and justified, and you claim that strike is a right, is a legal right, isn't it? So legal right means there should not be any deduction, there should not be any penalty, isn't it? But this is not the case. Strike has been considered a recognized right. It has not acquired the status of legal right or constitutional right or other rights. Read that B.R. Singh versus Union of India, Kameshwar Prasad, State of Bihar, several judgments, and the judgment T.R. Ragurajan versus Tamil Nadu 2003. But the judgment is related to government employees. Don't confuse, right? The judgment is related to government employees because government employees do not have any fundamental right, legal right, moral right to declare a strike. Services rules, right? The strike is prohibited. They can't declare any strike. Fine. So this is you must really understand the dimensions. Number one, civil protection. What about criminal protection? Right? There is a provision under section 17 or maybe 18, right? Criminal immunity is provided. What is the criminal immunity? Second part of section 120B. What is criminal conspiracy? Immunity is only available in case of criminal conspiracy arising out of 120B2. What is that? Can you explain that? Anybody? Yes. Okay. What is the ratio?
So, like that, the High Court and High Court gave judgment for 6 months rigorous imprisonment, but later the Upper Court held that the.
What is the conspiracy angle? This immunity is only available in case of there is a conspiracy, right? So, what is the conspiracy angle that is involved in case of the Registered Trade Union Act? See, friends, whenever employees declare strike, they conspire against employer, right? So that conspiracy against employer is protected. Strike is a kind of conspiracy against employer. Whenever strike is declared, it means that workers conspired against employer to discontinue work. So that conspiracy under IPC, now I think you would find different provision under that DSNLU Act, right? 120B second part where punishment is less than 6 months. So that criminal immunity is available. Employer cannot file any prosecution proceedings against employees for criminal conspiracy because they come together, they conspire against employer and declare a strike. So that conspiracy is protected. But if the workers conspire to sabotage or damage the property of employer, the protection is not available under the relevant section of Trade Unions Act. So you have to really understand that. Protection is confined to only that criminal conspiracy to declare a strike, criminal conspiracy to the suspend relationship between employer and employee, right? So that is the angle available. Okay, what about 19? Section 19 of Trade Unions Act. Restrain. Agreement in restraint with trade and business. Whenever strike is declared, it means the parties enter into some agreement to affect trade and business. Otherwise, that Contract Act, Indian Contract Act, I think section 27. Any agreement in restraint with trade and business shall be null and void. That is general agreement. But if you compare section 19 of Trade Unions Act, what is the legal status? Section 19 protects that agreement between workers, restraining trade and business. That is protected, that is immediately available. So 17, 18 and 19 is very important, right? So, but friends, you can't examine Trade Unions Act without understanding ID Act, without understanding Employment Standing Orders Act, without understanding other legislations, right? Do you know something about collective bargaining? Right, what is collective bargaining?
Relation of give and take.
Hmm?
Relation of give and take.
Okay, anybody else? See, India has not ratified ILO's Convention 98 and 87. Fine. There are 10 core conventions, ILO's core conventions, which have been, I think 6 have been ratified by India. India has not ratified 4 core conventions, and it includes 87 and 98. These 2 provisions are related to right to strike, absolute right to strike, and right to collective bargaining. So what is collective bargaining, anybody? Do you think collective bargaining agreement is recognized by IDEA? Again, integration. When you study, yeah?
Bargaining with the in a amicable way between employers and employees.
Okay, fine. What is collective bargaining?
So when you say right, there is a dialogue between employer and employee to find out the middle way, the resolution. That is the collective bargaining, where both the parties on win-win situation.
Okay, before discussing collective bargaining, you must understand the modes of resolution of disputes, right? If you are required to examine all these parameters, kindly start from number 1, resolution of disputes. What are the modes? Number 1, settlement. Settlement means bipartite settlement or tripartite settlement. Number 2, investigation. Number 3, adjudication. So there are 3 important modes of resolution of dispute. Okay, coming back to that collective bargaining, right? So settlement, collective bargaining is a tool of settlement, right? It's a part of bipartite settlement. You know what is bipartite settlement? Collective bargaining is a negotiation between the parties, interested parties. Number 3, the next is tripartite settlement, right? Settlement through involvement of third party, like conciliation officer, board of conciliation, right? So this is the way you are required to examine settlement. Collective bargaining is very important component of that association of right, or workers association, right? So trade unions are formed or have been created to ensure better collective bargaining, right? You know that workers participation in management, level of workers participation in management. Any idea about Article 43A of the Constitution? You have discussed trade unions, but you are not aware of Article 43 capital A of our Constitution. Again, integrated understanding becomes very important. Otherwise, your understanding will be in isolation. You will be confined to only selective parameters, selective literature. See, you are required to examine constitutional paradigms of trade unions. 19(1)(c). You are also required to examine 43 capital A. What is 43 capital A? Anyone? Oh my God. What to do? Huh? What is 43A? I know 43A deals with directive principles of the state policy. What is 43A? How far 43A is related to Trade Unions Act? Participation of workers in the management of industry, right? And if you read section 22 of Trade Unions Act, what is that? Section 22 of Trade Unions Act.
Outsiders should be part of it.
Management, right? Workers associations are required to be governed by workers. This is association, right? And when it comes to workers participation in other committees, like works committee under section 3 of ID Act, right? Grievance and redressal committee under section 9A or C of Industrial Disputes Act, right? So this is regarding workers' participation. You require to form trade union to bargain, to participate. So that workers' participation can happen at various levels like information sharing, consultation, where workers are consulted, right? What is the highest level of workers' representation in the management? What is the highest level of workers' participation in the management? Anybody? See, like what happens in case of works committee, right? Works committee under section 3 of that ID Act, or grievance and redressal committee in case of ID Act. Employee is not bound by the decision of grievance and redressal committee. Fine. So no value. Some of the states have discontinued the practice of constituting works committee. So which is the highest level of workers' participation in the management? Information sharing, consultative, etc., etc. Anybody? Do you know something about workers' director? Have you heard of this term? Workers' director. Huh? You know, in Germany, Sweden, Finland, they have created a particular scheme called Determination Act, where they have created workers' director. Workers' director on the board of directors. This scheme was recommended long back in 1970. Justice Sachin committee. Some provisions were inserted in the Companies Act, but not approved by the government that time. Right? And you have some companies like you have Tata. Tata is a company, leading company, where they have appointed workers director. Right? So that is the highest level of workers participation is decision-making participation, where workers representative participate in decision-making process affecting workers. So therefore, friends, confining your discussion to only Trade Unions Act will not serve the purpose. You have to examine all the parameters of Trade Unions Act, constitutional paradigms, ID Act, right, and then see workers director. Fine. So otherwise the whole purpose of that learning would be defeated, because you know law in theory is very different from law in practice. Now coming back to that workers' participation in case of adjudication. Any idea about that? Workers' participation or trade unions' participation in adjudicated process. That is of ID Act. See, again integration. Piecemeal analysis is not going to serve the purpose. See, trade union or representative of trade unions can represent workers during conciliation proceeding, allowed, section 36 of section 3. Trade unions representative can represent workers before labor tribunal, before a labor court or industrial court. Right. Okay, what about advocates? Do you think advocates are allowed to practice before labor tribunal? Do you think advocates are allowed to practice before labor tribunals?
Yes, but normal people can also represent in labor courts. They can represent.
The question is, advocates are allowed or not allowed? Authorized person, anybody can represent in the capacity of authorized person or authorized representative, AR. What about advocates? What about advocates? Whether advocates can appear before? Have you visited any labor tribunal? Any one of you? You must visit labor tribunal. You must really visit conciliation officer, meet labor commissioners. Anyone? Let me see. Yeah, labor court. Whether advocates can appear before labor tribunal? Sure. Yeah? What is that? Just read section 36 subsection 4 of ID Act. Let me see. Yeah.
Legal professionals are prohibited unless there is a consent.
Yes. Legal practitioners, not professionals. A teacher is also professional, isn't it? It becomes too wide. Legal practitioners, you know, legal practitioners registered under Advocates Act, right? They are also covered under Legal Practitioners Act 1926. Fine. So I am talking about that person, a legal practitioner registered with Bar Council of India or state bar councils. Now see section 36 subsection 4. Let me see the parameter, and I tell you that what happens in practice is very different from your theory. What is section 36 subsection 4? And read 3 also, section 36 of section 3. 36(3), no legal practitioner is allowed during conciliation proceedings before conciliation officer or board of conciliation. Total bail. But friends, I have been visiting various agencies. Because I teach labor law means I must know what is the practical dimensions of labor law. Advocates appear as a matter of routine before conciliation officer. Now, number 2, subsection 36, the section 36, subsection 4, right? But if you go to any labor tribunal, isn't labor tribunal nearby? Have you seen? Just visit and see. Advocates appear before labor tribunal on behalf of workers, on behalf of employees, as a matter of routine. No permission is granted, no permission is required. That is the real character of labor law in practice, right? So if that is the case, can you expect the trade union to know all the dimensions of labor law? See, that time when labor law was implemented, right, we had learned advocates, learned trade union leaders, well versed with trade union law, well versed with constitutional law. Now things are very different because the trade unionization in India has been diluted. You know, what are the problems of trade unions in India? Anybody? I hope you have examined all the parameters of trade unions. What are the major challenges or contemporary challenges which are faced by trade unions in India? Yeah, gentlemen.
I can give my opinion, but I don't have any exact data or empirical.
I'm not asking you how many trade unions are affiliated with political parties. I'm not asking the data. Fine.
First thing that I understand incompetency.
Okay.
Incompetent leader.
That is very subjective. I know several trade union leaders. I know one particular person, advocate from Kerala, a former president of that BMS, Bharat Mazdoor Sangh.
And they are also not well aware regarding their rights, how to assert, on what point of view.
Have you visited any trade union office? BMS, EITUC, C2, Intec, any trade union?
Not the trade union, but the member of the trade union, I have read several times of DSNLU.
Okay.
Many times.
In line of membership.
Okay. You know the problem? Problem regarding membership. A person can become member of any number of trade unions. There is no restriction regarding duplication. Right? A person can become member of several trade unions by paying 1 rupee or 10 rupees. And this is one of the major reasons of multiplicity of trade unions. You know the procedure for registration of trade unions? 7 or more people can subscribe to any trade union. They have to just, right, complete that application, then attach the constitution of the trade union, right, and process it. So 7 or more people can constitute, but there is restriction regarding the 10%. Fine. So I can be a member of several trade unions because you require 7 people, right? So 10 people can create so many trade unions. So the real problem is multiplicity of trade unions. Number 2, political affiliation of trade unions. You know, BMS is affiliated to BJP, right? Intec is affiliated to Congress, ATEC is affiliated to CPI, etc., etc., etc. There is a long list of that political affiliation. Go to West Bengal, go to Kerala, trade unions dominate because the trade unions are supported by state government. Go to Gujarat, see that state of affairs. Go to Haryana. Have you seen that Maruti episode? How the workers were thrashed by police, right? Now, of course, the manager was also killed. That is also not appreciated in any case. That is illegal, right? So that is multiplicity of trade unions is a serious problem. Political affiliation of trade unions is again a serious problem. So you have to really examine all those parameters, right? So without understanding these issues, you won't be in a position to appreciate trade unions act, friends. And tell you, because the time constraint, you have some different requirement. I tell you, see, what is required by the profession? What about labor law or maybe administrative law or any law, right? The profession requires competent and devoted professionals Competent means knowing the subject matter. Devotion means commitment. Right? So we require devoted and committed professionals who can excel anywhere in the world. Number one. Number two, the professional efficiency is very, very important. If you are not capable, it's a matter of demand. If you are a good professional, people are going to involve you, invite you. But if you are not so clear about basic concept, I think nobody is going to invite you, nobody is going to involve you. Right? That is a real problem. Nobody is going to listen to you. So I think there are four important, fundamentals of life. It is up to you how really interpret, analyze these fundamentals. Number one is no shortcut to success. It is always the hard work. So kindly work hard to know more and more about labor law and an integrated approach, because labor law deals with multidisciplinary approach. Right? It is not confined to only one parameter. Right? Number two, use your discretion. Don't borrow it from others. You are the best person to decide what is right and what is wrong. Right? Have independent opinion, independent argument. Number three, you can never progress at the cost of somebody. You can never progress by pulling down somebody. Right? So you can progress at your own. And the last one is never blame others for your failure, your inaction, or your pitfalls. So therefore, acknowledge your pitfalls, introspect your performance, and try to overcome those limitations. See, no one is perfect. Mann is also not perfect. Right? After all, we are a human being. But the moment you acknowledge your limitation, you will be in a better position to overcome your limitations. Otherwise, it is very easy to blame others. So don't blame others for your failures, for your inaction. Right? Introspect yourself, and this is the best way to really grow as a competent professional. Right? So friends, take it for granted. If you are committed, if you are devoted, you are honest, people will appreciate you. May not be today, but certainly tomorrow. Right? So any question, any clarification, because I don't enjoy interaction without quality contents. That is, I think, that my problem. Right? If I deliver some lecture, I'm part of some discussion, I love to interact. Right? So let us see how you improve that. I'm not blaming you for that purpose, right? But acknowledge that limitation. Try to overcome those issues and learn more and more and more with integrated approach. Don't confine to only IDEA. IDEA deals with so many dimensions. Trade Unions Act deals with so many dimensions, right? So let us have that understanding. Fine. So any question, any clarification regarding that? Anyone? You know, Socrates' method of learning is very important. You learn by raising questions. And the person who knows something can only raise pertinent questions. This is also important. Right? So friends, I conclude my discussion and presentation. If you have any specific question you like to have some discussion on particular parameter, this is my extempore discussion, right? But because of my passion for labor law, my interest, right, and then again my involvement in labor law, I'm a student of labor law, again learning the real character of labor law, right? See, first generation reform, what is happening in case of second generation reform after 1991, right? So let me see if you have some inputs, some reasonable criticism is also appreciated. Yeah, any question, any clarification, friends? Fine? Okay, then all the best, take care, enjoy yourself. That's it. Thank you.